everyone. My name is April Hulst, and I'm an attorney at the law firm Chase Bylenga Hulst. Today we are going to be talking about a topic that is important for everybody to know about, and that is estate planning. To begin with, what is estate planning? The most basic definition of estate planning is putting together a plan in advance of your death that states your wishes on who you would like to care for your children and who you want to receive your things. Your estate will consist of any property that you own at the time of your death. That will include your home, any other real estate you may own, personal property such as cars and furniture, and other properties such as insurance, bank accounts, retirement accounts, pensions. Basically, anything that is in your name at the time of your death could be a part of your estate. The main documents that can be included with an estate plan are typically a last will and testament, a revocable trust, a designation of patient advocate, and a durable power of attorney. I'm going to go through just the basics about those documents with you today so you have an idea of what is included. The will is created at the time that you are living and is carried out at your death. In a will, you will choose one or two people to essentially administer your estate. You will state your wishes on how you'd like your property to pass at your death, and it will also give you the opportunity to choose who you want to be the guardians and conservators for any minor children that you may have. One thing to note is if you have just a will at the time of your death and a revocable trust is not included in your estate plan, you may have to go through probate, which brings us to our next question: what is probate? Put simply, probate is the process of administering assets through the court, and that can be done supervised or unsupervised. Basically, the person that you appoint as your personal representative to manage your assets doesn't have the authority to do that without being appointed by the probate court first. So there's a lot of paperwork that has to be filed in order to do this. Once the probate court appoints that person and gives them this authority, they'll be able to go about identifying any assets, paying any creditors, and distributing assets to your beneficiaries. The next document that can be included in a typical estate plan would be a revocable trust. A revocable living trust is created during your lifetime and is used to manage your assets both during your lifetime and at your death. A revocable trust has a lot of benefits that can't be done through a will. For instance, a revocable trust can help you eliminate or reduce federal estate taxes. A revocable trust gives you complete control over how and when assets are distributed, which is particularly useful if you have minor children involved. The trust is also private, which is something that is different than a will. A will is going to have to be filed with the probate court, whereas a trust typically does not need to be filed and can stay private. Next, we have the powers of attorney. The first is a durable power of attorney, and this is where you will appoint an agent to act in your best interest to handle your financial affairs, either in your absence or if you become incapacitated. A durable power of attorney is typically effective upon the date that it is signed. However, you can create one so that it's effective upon your incapacity. One thing to keep in mind when designating an agent for your durable power of attorney is to select someone that you trust, because they will have access to all of your finances. The designation of patient advocate, you will also select an agent for. However, that agent will be making medical decisions on your behalf when you are unable to. And the designation of patient advocate is not effective upon the signing date. It's actually only effective when you're unable to make those decisions yourself. In the designation of patient advocate, you can also state how you want certain medical treatments to be given in situations, such as what life-sustaining measures you want taken. You can designate whether or not you want to donate your organs and your body parts to science as well. A question that I typically get from clients or individuals who are considering doing an estate plan is, what will happen if I don't do anything? And the simple answer to that is that the state will essentially write a will for you. They will decide who is going to care for your children, a decision that a parent will undoubtedly want to be a part of. They will decide who's going to get your assets, and that is going to be the heirs as determined by state law. You will not have any say in how and when those assets are distributed. And your family will likely have to go through probate, which can be a rather costly process to go through. If you'd like to learn more about estate planning, we do offer free consultations. Please feel free to contact us today.